In office property management in Needham, Massachusetts, signing an incident report without verifying liability exposure doesn't just document what happened. It commits you to a version of events before you know whether it protects your position or destroys it. The report goes into the file. Months pass. A claim surfaces. Your own documentation becomes the primary evidence working against you. Witness consistency is the first item most owners never check. The manager drafts the report based on their walkthrough or a phone call with building staff. You sign it. But if that report references witness statements you never independently verified, you're certifying accounts you can't actually confirm. An attorney deposing your property manager 6 months later asks whether you personally validated those witness descriptions. You didn't. The opposing counsel uses that gap to challenge the credibility of your entire incident record. Timing discrepancies create the second failure point. The report lists a specific time for when the incident occurred, but if that timestamp conflicts with access logs, security footage, or contractor sign-in sheets, the problem doesn't surface until discovery and litigation. By then, you've already signed a document that contradicts your own building systems. The plaintiff's attorney argues the inconsistency shows either negligence in your record-keeping or deliberate misrepresentation of the timeline. Injury severity documentation is the third exposure most owners treat as clerical. The report describes the injury as minor or superficial. You sign off assuming it's accurate. 6 months later, the injured party files a claim alleging permanent impairment and ongoing lost wages. Your signed report, minimizing the severity, becomes Exhibit A. In their argument that you failed to take the incident seriously, didn't provide appropriate immediate response, and created a record designed to limit your liability rather than document reality. Comparative fault language creates the fourth risk. If the report implies the injured party contributed to the incident, but doesn't document exactly how or provide supporting evidence, you've asserted a defense you can't prove. The claim escalates to litigation. Your insurance carrier reviews the file and asks for contemporaneous evidence backing the fault allocation in your signed report. You don't have it. The carrier settles at a higher number than necessary because your own documentation weakened the defense before the claim was even filed. Corrective action commitments are the fifth problem. The report states you will remediate the hazard or address the underlying condition. You sign it. But if that corrective work isn't completed on the documented timeline, or isn't completed at all, that signed commitment becomes direct evidence of admitted knowledge and failure to act. A second incident occurs in the same area months later. Your prior report proves you identified the risk, documented intent to fix it, and then didn't follow through. Every signature converts a narrative into a binding representation of what you knew and what you failed to do about it. To discuss your office building, tenant considerations, or capital planning decisions, schedule a consultation at 781-531-9167.